Welcome once again to our continuing YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular YouTube video, we will be discussing what is termination without cause. Now, the essence of termination without cause is that the employer is terminating an employee without citing a basis upon which there was a fundamental breach by the employee of the employment relationship, whether that is due to the employee having undertaken actions which are grossly inconsistent with the employment relationships, or has undertaken actions which are substantially prejudicial to the employer's business. Now, I wish to caveat that because, as we discussed in the description of termination for cause, the standard for termination for cause is such a high standard. And with the judicial system looking more often than not to protect the lesser of the individuals, hence the employee, the standard and the bar that the employer must reach is quite significant, such that even though an employer might feel like there is a basis for cause upon which they might terminate the individual and thereby avoid the provision of the requisite statutory and common law notice, or payment in lieu of that notice, and possibly other severance matters. The reality is that the judicial system and the cases are such that the bar is so high that one needs to seriously consider that even if they feel that there may be cause, the approach, and they should take specific legal counsel on this, they may well be necessitated and be the smarter move to pursue the matter as termination without cause. And yes, this will accrue to the employer that they will have to either provide the notice required by law, or more likely termination pay in lieu of notice, and potentially severance pay, such that they will not be getting away with avoiding such payments. The issue, though, is in making these payments, getting the requisite releases, waivers, sign-offs, you are able to manage the relationship, post-relationship matter more effectively, and you are able to avoid judicial proceedings wherein the employee takes the employer to court, demands far more than what would otherwise be provided, and not only demands more and most likely gets more or gets a larger settlement, but also forces the employer to incur significant legal costs in the defense of his position, but also receives significant acrimony and opposition with respect to their employment practices, which is a major consideration and a rationale for proceeding for termination without cause, where the case that they have is not as strong as they might otherwise expect. Naturally, everything is dependent upon the facts, the prevailing case law and law in the jurisdiction, and how it will be interpreted, which is critical to these matters. Thank you.